I found out my neighbor was destroying my house when I opened my June water bill and nearly choked on my morning coffee. $372 for a single month in Phoenix, Arizona, where I'd been gone for 2 weeks visiting my brother in Seattle. Something was seriously wrong. My name is Gabriel Zimmerman, and I'd lived in the Saguaro Heights development for 3 years without incident. I'm a software engineer who works remotely, 34 years old, and I'd saved for years to buy my modest 3-bedroom house with the desert landscaping I'd meticulously installed myself. Rock gardens, native plants, the whole sustainable Arizona aesthetic. My water bill normally hovered around $80 a month, even in summer. I called the water company first thing Monday morning. The representative, a patient woman named Sandra, walked me through my daily usage logs. The spike started on May 15th and continued through the billing period. Massive water consumption every single day between 6 and 8 in the morning, and again from 7 to 9 in the evening. "Sir, are you sure you don't have a leak?" Sandra asked. "This pattern suggests someone is running sprinklers or a hose for extended periods." "I don't have sprinklers," I said, staring out my kitchen window at my rock garden. "I specifically designed my yard to avoid them." That's when I noticed the dark staining on my foundation. The concrete along the east side of my house, the side facing my neighbor's property, looked wet. Not just damp, saturated. In Phoenix, in June, when we hadn't seen rain in 43 days, I walked outside in the 105-degree heat and immediately understood. My neighbor's sprinkler heads, the ones along her property line, were angled directly at my house. Water was spraying across the 3-foot gap between our properties and hitting my foundation in pulsing streams. As I stood there, the system kicked on. 6 sprinkler heads rotated and sent water arcing through the air, splashing against my concrete foundation, my exterior wall, pooling against the base of my house. "What the hell?" I muttered, walking along the property line. The ground on my side was muddy, completely saturated. I could see watermarks on my stucco exterior climbing at least 2 feet up the wall. This wasn't accidental overspray. The sprinklers were deliberately aimed across the property line. My neighbor was Brenda Hutchison, the vice president of our HOA and the most Karren-like person I'd ever encountered in my life. She was 47, drove a white Lexus SUV, and had called code enforcement on 6 different neighbors in the past year for violations ranging from unapproved mailbox colors to excessive holiday decorations. She tried to fine me twice, once for leaving my trash cans visible from the street on a non-collection day. I'd been loading them into my garage. And once for having a commercial vehicle in my driveway, my Honda Civic with my company's small laptop bag on the passenger seat, visible through the window. I'd never adjusted her sprinklers to point at my house. There was no reason for this except malice. I pulled out my phone and took pictures. 15 photos from different angles showing the sprinklers actively spraying my foundation, the water pooling against my house, the mud, the staining. Then I recorded a video, narrating what I was seeing. It's June 18th, 10:03 in the morning. My neighbor's sprinklers at 4782 East Saguaro Drive are spraying directly onto my property at 4780 East Saguaro Drive, hitting my foundation and exterior walls. You can see the water is angled deliberately across the property line. This has apparently been happening for at least a month based on the staining and damage. The sprinklers shut off after 20 minutes. 20 minutes of water hammering my foundation twice a day. I did the math. That was over 40 hours of water exposure in a month. On my foundation. In Arizona, where houses aren't built for that kind of moisture, I knocked on Brenda's door. She answered wearing yoga pants and a visor, her highlighted blonde hair pulled into a severe ponytail. Her expression soured the moment she recognized me. "What?" she said, not opening the screen door. "Your sprinklers are pointed at my house," I said, keeping my voice level. "They're spraying my foundation for hours every day. You need to adjust them back onto your property." "My sprinklers are on my property," she said. "I can point them wherever I want. They're spraying water onto my house. That's causing damage to my foundation and my exterior walls. Prove it." She started to close the door. "Brenda, I have pictures, I have video. Your sprinklers are clearly aimed across the property line. This isn't overspray, they're deliberately pointed at my house. If you have a problem, take it up with the HOA," she said. "I'm sure we'll find you're in violation of something. Your rock garden looks like a junkyard, by the way. I've been meaning to cite you for that." She closed the door in my face. I stood there for a moment, processing the interaction. She wasn't denying it. She wasn't even pretending it was accidental. She was telling me explicitly that she was doing this on purpose and dared me to do something about it. I went home and started researching. Foundation damage from water exposure in Arizona is no joke. Our soil is clay-based and expansive. When it gets wet, it swells. When it dries, it contracts. Repeated cycles cause foundations to crack, shift, and fail. Repairs start at $10,000 and go up from there. Severe damage can make a house uninhabitable or unsellable. I'd bought moisture sensors the previous year for a project at work that never materialized. They were industrial-grade sensors that logged data to a cloud server. I'd paid $200 each for 3 of them, and they'd been sitting in my garage ever since. That afternoon, I installed all 3 sensors along my foundation on the east side of my house. I mounted them directly to the concrete, spacing them evenly across the 20-foot span where the sprinklers were hitting. Each sensor connected to my home Wi-Fi and started uploading moisture readings every 60 seconds to a cloud database. I configured email alerts for when moisture levels exceeded normal parameters. Then I sent Brenda a certified letter, return receipt requested, formally notifying her that her sprinklers were trespassing on my property, causing water damage to my foundation, and requesting that she adjust them within 5 days. I kept a copy for my records and sent it that afternoon. The next morning at 6:07, my phone erupted with alerts. All 3 moisture sensors detected massive spikes in moisture levels. I pulled up the monitoring app and watched in real time as the readings climbed from baseline levels of around 5% relative humidity to over 90%. The sensors were getting drenched. I went outside with my phone and recorded another video. The sprinklers were running at full blast, water arcing across the property line, hammering my foundation. I recorded for 5 minutes, making sure to capture the timestamp, the water hitting my house and the pooling at the foundation base. When the sprinklers finally shut off after 23 minutes, I checked the moisture logs. Perfect. 3 separate sensors, 3 separate data streams, all showing the exact same pattern. Normal baseline levels, sudden spike to 90+%, sustained for 23 minutes, then gradual decline. The timestamp was recorded down to the second. That evening, the same thing happened. 6:51 p.m., all 3 sensors detected water. I recorded another video. 21 minutes of sprinklers blasting my house. 5 days later, I received the return receipt showing Brenda had signed for my letter. The sprinklers continued running unchanged. Morning and evening, like clockwork, water hammered my foundation. I called a foundation inspection company. They sent out a specialist named Ron, a weathered guy in his 60s who'd been inspecting Arizona foundations for 30 years. He took one look at my east wall and whistled. "This is bad," he said, kneeling by the foundation. "You've got significant moisture intrusion. The stucco is saturated. The concrete is showing efflorescence. See these white deposits? That's salt being pulled out of the concrete by water movement. You've got the start of foundation damage here." "How bad?" I asked, already dreading the answer. Ron pulled out a moisture meter and started taking readings. "The concrete is reading 18% moisture content. It should be under 6%. You've got water penetrating deep into the foundation. I'd need to do a full structural inspection to tell you if there's cracking or shifting, but if this continues, you're looking at serious problems. Foundation cracks, interior wall cracks, doors and windows that won't close properly. Could affect the structural integrity of the whole house." "What's the repair cost right now?" "You need to stop the water source, let everything dry out completely. That'll take months in this humidity, then seal and waterproof the foundation. Call it $3,000 to $5,000. If there's already structural damage, $10,000 to $30,000, depending on severity. Could be more if we find significant cracking." I had him do the full inspection. It cost me $600, but Ron was thorough. He measured everything, took moisture readings at dozens of points, checked for cracks in the foundation and interior walls, tested door and window alignment, and examined the crawl space. His report, delivered 2 days later, was 19 pages long. The summary: significant ongoing moisture intrusion to east foundation wall. Current moisture levels 18 to 22% in foundation concrete, 12 to 15% in adjacent soil, significantly elevated from normal Arizona baseline of 3 to 6%. Early evidence of foundation stress, including minor efflorescence and surface spalling. No structural cracks detected at this time, but continued moisture exposure will cause progressive damage. Source of moisture appears to be neighbor's irrigation system. Recommend immediate cessation of water exposure and professional foundation remediation. Estimated current damage cost, $4,200. Potential future damage if exposure continues, $15,000 to $40,000. I had my documentation. Now I needed a lawyer. I found Teresa Sanchez through a colleague's recommendation. She specialized in property disputes and HOA law, which in Arizona is apparently a whole subspecialty because HOAs here have incredible power. Her office was in Scottsdale, and she agreed to see me that Friday. Teresa was sharp, probably in her early 50s, with dark hair and an expression that suggested she'd seen every variety of neighborhood conflict imaginable. I laid out everything: the water bill, the photos, the videos, the moisture sensor data, the inspection report, the certified letter. She reviewed it all carefully, pulling up my sensor data on her computer and watching the moisture level graphs. "This is excellent documentation," she said. "You've got time-stamped data from multiple independent sensors, all showing the same pattern. You've got video evidence. You've got a professional inspection report quantifying the damage. And you've got proof you notified her and she refused to stop." "What are my options?" I asked. "Several. First, you can file for a temporary restraining order to stop her from continuing the water trespass. Second, you can sue her for the existing damage and the cost of repairs. Third, since she's an HOA officer, you can file a complaint with the HOA board. Fourth, you could potentially file criminal charges for property damage or vandalism, though that's a long shot. Will any of that actually work?" Teresa leaned back in her chair. "The TRO should work. You've got clear evidence of ongoing property damage. The lawsuit should work too. Arizona law is very clear on water trespass and property damage." The HOA complaint is iffy because she's the vice president, but you should file it anyway for the record. Criminal charges probably won't go anywhere unless the damage gets more severe. What about the HOA? She said she's going to cite me for violations. Let her try. If she retaliates against you for complaining about legitimate property damage, that's illegal retaliation and strengthens your case. Document everything she does. Every citation, every fine, every interaction. It all becomes evidence of her malice. I hired Teresa on the spot. She charged $250 an hour, which hurt, but this was my house we were talking about. She filed for a temporary restraining order that afternoon. Meanwhile, the sprinklers kept running. My moisture sensors kept logging data. Every morning and evening, like clockwork, water blasted my foundation. I recorded video at least once a day, building a comprehensive evidence file. 4 days later, I got a citation in my mailbox. HOA violation notice, signed by Brenda Hutchison, citing me for unsightly landscaping that degrades neighborhood aesthetics in violation of HOA Covenant Section 4.3. The fine was $100, increasing to $200 if not remedied within 14 days. I called Teresa immediately. She laughed. Perfect. She's creating evidence of retaliation. Don't pay the fine, we'll fight it. The hearing for the TRO was scheduled for July 9th. I showed up at Maricopa County Superior Court with Teresa, carrying a laptop and a folder containing printouts of everything. Brenda showed up with her own lawyer, a guy named Mitchell something who looked expensive. The judge was a woman in her 60s named Patricia Orozco. She looked tired and not particularly interested in hearing about sprinkler disputes. Teresa presented our case methodically. She showed the moisture sensor data, explaining how the 3 independent sensors all showed identical patterns of water exposure twice daily. She played video clips of the sprinklers actively spraying my foundation. She submitted the inspection report documenting the damage and quantifying the repair costs. Your Honor, this is clear, ongoing property damage, Teresa said. The defendant has been notified multiple times. She has refused to stop. Every day this continues, Mr. Zimmerman's foundation sustains additional damage. We're requesting a temporary restraining order requiring the defendant to adjust her sprinklers away from my client's property while we pursue the underlying lawsuit for damages. Mitchell stood up. Your Honor, Mrs. Hutchison's sprinkler system is entirely on her own property. She has every right to irrigate her lawn as she sees fit. If some minor overspray crosses the property line, that's a natural consequence of normal property use. This is the desert, everyone uses sprinklers. Mr. Zimmerman has no standing to dictate how his neighbor waters her plants. Judge Orozco looked at him. Counselor, did you review the evidence? The sensor data shows sustained water exposure for over 20 minutes, twice daily. The video shows significant water volume crossing the property line. This isn't overspray. It's irrigation, Your Honor, completely normal. The judge pulled up one of my videos on the court computer. We all watched as water arced across the property line and splashed against my foundation. She watched the entire 3-minute video without comment. Mrs. Hutchison, the judge said, looking at Brenda. Why are your sprinklers aimed at your neighbor's house? Brenda stood up. She dressed in a business suit and looked every inch the responsible homeowner. Your Honor, my sprinklers are positioned to water my lawn and flower beds, which are located along that property line. I've lived in that house for 12 years. My landscaping complies with all HOA requirements and city ordinances. If Mr. Zimmerman has concerns about overspray, he could install a barrier or adjust his own property to accommodate normal neighborhood living. Did you receive Mr. Zimmerman's letter asking you to adjust the sprinklers? I did, Your Honor. I considered his complaint and determined it had no merit. My sprinklers are on my property. But they're spraying water onto his property. Minimal overspray, Your Honor, inevitable in any irrigation system. Judge Orozco looked at the moisture data again. Counselor Sanchez, these sensors, how reliable are they? Teresa stood. Your Honor, they're industrial-grade environmental sensors manufactured by Bosch. They're designed for commercial construction monitoring and have an accuracy rating of plus or minus 2%. They log data continuously to a cloud server with tamper-evident timestamps. The data Mr. Zimmerman collected is objectively reliable, and all three sensors show the same pattern. Yes, Your Honor, identical patterns twice daily for over a month. You can see in the logs that the moisture spikes correspond exactly with the times Mrs. Hutchison's irrigation system runs. We also have video evidence from multiple dates showing the sprinklers actively spraying Mr. Zimmerman's foundation during those exact time windows. The judge was quiet for a moment, reviewing the documents. Mr. Zimmerman, do you have sprinklers on your property? I stood. No, Your Honor. I designed my landscaping specifically to avoid irrigation. I use desert plants and rock gardens that don't require watering. And your water bill increased dramatically during this period. Yes, Your Honor, from around $80 a month to over $300. The water company confirmed the spike started exactly when the sprinkler pattern started showing up in my sensor data. Judge Orozco looked at Brenda. Mrs. Hutchison, I'm trying to understand this. Your neighbor doesn't use sprinklers, yet his water bill tripled. His sensors show sustained water exposure from a source on your property. The video shows your sprinklers spraying across the property line, yet you claim this is normal. Mitchell stood. Your Honor, we dispute that the water consumption increase is related to any alleged overspray from Mrs. Hutchison's property. Mr. Zimmerman may have a leak or other source of water consumption. The water company traced the usage to his outdoor meter, Teresa interjected. Someone was using massive amounts of water outside Mr. Zimmerman's house. He doesn't have sprinklers. The only possible source is the water from Mrs. Hutchison's sprinklers hitting his property and triggering his meter. I blinked. I hadn't thought of that, but Teresa was right. If enough water was splashing onto my property and into my drainage system, it could theoretically register on my meter if any of it was flowing through my outdoor faucets or connections. Though honestly, the water company had probably just seen the spike and assumed it was my usage without investigating the source carefully. Judge Orozco made a decision. I'm granting the temporary restraining order. Mrs. Hutchison, you are ordered to adjust your sprinkler system so that no water crosses the property line onto Mr. Zimmerman's property. You have 48 hours to comply. If Mr. Zimmerman's sensors detect water exposure after that time, you'll be in contempt. You understand? Brenda's face flushed red. Your Honor, this is outrageous. I'm being ordered to modify my property based on unproven claims. Mrs. Hutchison, I've reviewed the evidence. The claims are well documented. Adjust your sprinklers. Court adjourned. We left the courthouse victorious. Teresa was pleased. That went better than expected. Judge Orozco saw through the nonsense. Now we file the lawsuit for damages and wait for her to comply with the TRO. What if she doesn't comply? I asked. Then she's in contempt of court. She'll face fines and potentially other sanctions. Most people comply. Brenda wasn't most people. That evening, my sensors detected water at 7:14 p.m. The pattern was identical to before sustained moisture spike, over 20 minutes of exposure. I immediately recorded video and emailed everything to Teresa. The next morning, same thing. 6:09 a.m., water exposure, sensors going crazy. Teresa filed a motion for contempt that afternoon. We had a hearing scheduled for July 16th, exactly 1 week later. In the meantime, I started getting more HOA citations. On July 11th, I received a notice citing me for parking a work vehicle in the driveway overnight in violation of Covenant Section 6.7. My Honda Civic was apparently now a commercial vehicle because I'd left my laptop bag visible again. Fine, $150. On July 13th, another notice for failure to maintain lawn borders because some of the decorative rocks in my garden had shifted slightly onto the sidewalk after a dust storm. Fine, $100. On July 15th, a notice for unapproved exterior modifications because I'd installed the moisture sensors on my foundation. Apparently they were visible from the street and violated the aesthetic guidelines. Fine, $200. Teresa collected all of them. She's burying herself. This is textbook retaliation. Document everything but don't engage, don't pay the fines. We'll deal with it all at once. The contempt hearing was brief. Judge Orozco reviewed the sensor data from after her TRO order. The moisture spikes were clearly visible, continuing twice daily without interruption. "Mrs. Hutchison, did you adjust your sprinklers as ordered?" the judge asked. "Yes, Your Honor," Brenda said confidently. "I personally adjusted them the day after the hearing." "Then why is Mr. Zimmerman's sensor data showing continued water exposure?" "I have no idea, Your Honor. Perhaps his sensors are malfunctioning, or perhaps he's spraying water himself to create false evidence." Teresa stood. "Your Honor, we have video evidence from after the TRO was issued showing Mrs. Hutchison's sprinklers still spraying Mr. Zimmerman's foundation." She played a video I'd recorded on July 14th. Clear as day, Brenda's sprinklers were spraying across the property line, water hitting my foundation in pulsing streams. The video timestamp was visible in the corner. Judge Orozco's expression darkened. "Mrs. Hutchison, that video was taken 4 days after my order. Your sprinklers are clearly not adjusted." "Your Honor, I did adjust them. If they've shifted back, that's due to water pressure or normal system operation. I can't control minor variations. This isn't a minor variation. This is deliberate non-compliance. Mrs. Hutchison, I'm holding you in contempt. You're fined $1,000 due immediately. You have 24 hours to properly adjust your sprinklers and provide proof to Mr. Zimmerman and the court that you've done so. If there's any further water exposure after that, the fine will be $5,000 and I'll consider additional sanctions including possible jail time." "Am I clear?" Brenda looked shocked. "Your Honor, this is completely unfair. 24 hours, Mrs. Hutchison. Dismissed." I went home feeling vindicated but exhausted. This whole thing was consuming my life. I was spending hours every day monitoring sensors, recording videos, communicating with Teresa, and dealing with the stress of knowing my foundation was being destroyed. The next day, I watched from my window as a landscaping crew showed up at Brenda's house. They spent about 2 hours working on the sprinkler system. I saw them adjusting sprinkler heads, repositioning some, and testing the system. When they finished, the supervisor came to my door. "Mr. Zimmerman, I'm Dan from Desert Bloom Landscaping. We just finished adjusting Mrs. Hutchison's sprinkler system per the court order. All the heads along your property line have been repositioned to spray onto her property only. I took photos and measurements for the court. If you have any issues, here's my card." "Thanks," I said, taking his card. "I appreciate you doing this right." "No problem. Between you and me, I don't know what the hell she was thinking. Those sprinklers were aimed at your house like she was trying to pressure wash it. That's not an accident." That evening, I monitored my sensors closely. 7 p.m. came and went. No water. The sensors showed baseline levels. 8 p.m., still nothing. I checked the video feed from the security camera I'd installed covering the property line. Brenda's sprinklers ran, but the water stayed on her property. The adjustment worked. I sent the data to Teresa. "Looks like she finally complied." "Good," Teresa replied. "Now we focus on the lawsuit I'm filing this week." The lawsuit was filed on July 22nd. Gabriel Zimmerman v. Brenda Hutchison. Case number CV 2024-009847, seeking damages for property damage, cost of repairs, emotional distress, and legal fees. Teresa itemized everything. The $4,200 foundation repair cost from Ron's estimate, my increased water bills, the cost of the moisture sensors and security cameras, Teresa's legal fees, and $5,000 for emotional distress and loss of enjoyment of property. Total damages sought, $38,700. Brenda's response came through her lawyer 3 weeks later. They denied all allegations, claimed the water exposure was minimal and caused no damage, and filed a counterclaim against me for $15,000, alleging I had harassed Brenda, caused her emotional distress, and damaged her reputation in the HOA. The discovery phase was exhausting. Both sides requested mountains of documents. Teresa requested Brenda's sprinkler system installation and maintenance records, her water bills, communications with the landscaping company, and any HOA records related to me or our dispute. Brenda's lawyer requested my sensor installation records, all my videos and photos, my complete water billing history, communications with anyone about Brenda, and my employment records for some reason. During this time, the HOA violations continued. I received 2 more citations in August, one for having my garage door open for more than 2 consecutive hours. I'd been working on my car, and one for excessive noise, because I'd used a power drill on a Saturday morning to hang some shelves. In September, I received a notice that I was being fined a total of $850 for the accumulated violations, and that the HOA was placing a lien on my property if the fines weren't paid within 30 days. Teresa filed a separate lawsuit against the HOA for harassment and illegal retaliation. That case, Zimmerman v. Saguaro Heights HOA, was filed in early October. The foundation lawsuit went to trial in November. We'd been unable to settle. Brenda refused to acknowledge any wrongdoing, and her lawyer kept insisting the damage was minimal or non-existent. Trial lasted 3 days. Teresa called me as the first witness and walked me through everything. I explained the water bill increase, finding the sprinklers aimed at my house, installing the sensors, the readings, the videos. Teresa introduced all of it as evidence. The sensor data logs, printed out and showing clear patterns of twice daily water exposure, the videos showing the sprinklers spraying my house, the inspection report. Ron testified about the foundation damage. He brought photos and moisture readings and explained in detail why sustained water exposure to an Arizona foundation was so destructive. "In the desert, we build for dry conditions," he explained. "Foundations here aren't waterproof the way they are in wetter climates. Repeated moisture exposure causes the clay soil to swell and contract, which stresses the concrete. The efflorescence Mr. Zimmerman's foundation showed is early evidence of that damage. If it had continued, he'd be looking at major structural repairs." Teresa introduced the certified letter I'd sent to Brenda, with the return receipt showing she'd signed for it. Mr. Zimmerman notified Mrs. Hutchison of the problem in writing. She did nothing. The water exposure continued for another 2 months until the court ordered her to stop. The sensor data was the star of the show. Teresa pulled up graphs showing the moisture levels over time. You could see the baseline readings, flat and steady, then sudden vertical spikes twice a day, sustained for 20 to 25 minutes, then gradual declines back to baseline. The pattern was identical every single day. This is objective, time-stamped data from 3 independent sensors, Teresa told the jury. All 3 showed the exact same pattern. This wasn't a leak. This wasn't random. This was water being deliberately sprayed onto Mr. Zimmerman's property at the same times every day. Mitchell, Brenda's lawyer, tried to discredit the sensors. He brought in his own expert, an engineer who testified that environmental sensors could be unreliable, that moisture readings could be affected by humidity and rain, that the data could have been manipulated. Teresa destroyed him on cross-examination. Mr. Patterson, you reviewed the sensor specifications, correct? I did. And these are commercial-grade sensors with plus or minus 2% accuracy, according to the specifications, yes. You testified that humidity could affect the readings. Phoenix humidity in June and July averages around 20%, correct? Approximately. Could 20% ambient humidity cause a moisture sensor in contact with concrete to suddenly jump from 5% to 90%? Well, no, but could rain cause that? Yes, if Phoenix had no rain between May 15th and August 3rd, 0 precipitation. Correct, Patterson hesitated. I'd have to verify. I have the National Weather Service data right here. 0 precipitation. So rain didn't cause these spikes, did it? No. You suggested the data could have been manipulated. These sensors log to a cloud server with cryptographic timestamps. Are you suggesting Mr. Zimmerman hacked the cloud server to falsify months of data? I'm saying it's possible. Are you aware that these servers are maintained by Bosch, a major international corporation, and that their security has never been breached according to any public record? I'm not aware of that specifically, no. So you're speculating. I'm offering possibilities, based on no evidence whatsoever. Objection, Mitchell stood. Argumentative. Sustained, the judge said. Move on, Counselor Sanchez. Teresa introduced the HOA violations I'd received. She showed the jury the stack of citations, all issued after I'd complained about the sprinklers. Mrs. Hutchison is the HOA vice president. Within weeks of Mr. Zimmerman complaining about the water damage, she began issuing violation citations for trivial or non-existent infractions. Parking his own car in his own driveway, having rocks on the sidewalk after a dust storm, installing sensors to monitor the damage being done to his property. This is retaliation. Mitchell objected repeatedly, but the judge allowed most of it as evidence of Brenda's state of mind and intent. Brenda testified on her own behalf. She maintained that her sprinklers were properly positioned, that any water crossing the property line was minimal, and that I was exaggerating or fabricating the damage. Mr. Zimmerman has been a difficult neighbor from the start, she said. He refuses to maintain his property to community standards. His yard is full of rocks and dead-looking plants. He parks wherever he wants. He leaves his garage door open for hours. I have a responsibility as an HOA officer to enforce our covenants. When he complained about my sprinklers, I reviewed his complaint and found it meritless. I adjusted them to be courteous, even though I wasn't obligated to. Teresa cross-examined her. Mrs. Hutchison, you testified that you adjusted the sprinklers to be courteous. When did you make that adjustment? Shortly after Mr. Zimmerman's letter, so in June. Yes, I believe so. But Mr. Zimmerman's sensor data shows water exposure continued through July. His sensors must be wrong. We have video evidence from July showing water spraying across the property line. I don't know what to tell you. I adjusted them. You were held in contempt of court in July for failing to adjust them. That was a misunderstanding. The judge fined you $1,000. The judge was mistaken. The judge reviewed video evidence showing your sprinklers spraying Mr. Zimmerman's house 4 days after she ordered you to stop. How was that a misunderstanding? Brenda's face reddened. I did adjust them. If they shifted, that wasn't my fault. Mrs. Hutchison, did you personally adjust the sprinklers or did you hire a professional? I adjusted them myself. Do you have any training in irrigation systems? I don't need training. It's basic. So you, with no training, adjusted sprinkler heads and then they mysteriously shifted back to spraying your neighbor's house. Apparently. Isn't it true that you deliberately aimed those sprinklers at Mr. Zimmerman's house as retaliation for prior disputes? Absolutely not. What disputes had you had with Mr. Zimmerman before this? He violated HOA covenants multiple times, such as his landscaping, his parking, his general disregard for community standards. Did you fine him for those violations? I issued citations, yes. Before or after he complained about the sprinklers, Brenda hesitated. Some were before. How many? I don't recall exactly. Teresa pulled out a document. I have the HOA records. You issued Mr. Zimmerman 2 citations total before June of this year. Both were dismissed by the HOA board as unfounded. After June, you issued him 8 citations in 3 months. Doesn't that seem like retaliation? It seems like he started violating rules more frequently. Or you started looking for reasons to fine him. Objection, speculation, Mitchell said. Withdrawn. Mrs. Hutchison, why did you install sprinklers along that particular property line? To water my plants. What plants? I have flower beds along that fence. The fence is on the property line, correct? Yes. So your flower beds are directly adjacent to Mr. Zimmerman's property? Yes. Wouldn't it make more sense to position sprinklers to water from above, rather than spraying horizontally across the beds toward your neighbor's property? I positioned them the way my landscaper recommended. Your landscaper recommended spraying water at your neighbor's house. No, he recommended positions to water the plants. Then why were the sprinklers aimed across the property line? I don't know. I didn't aim them. You testified earlier that you adjusted them yourself after Mr. Zimmerman complained. I did adjust them. So you did position them. Brenda's face was bright red. I adjusted them back to where they should be, where they were before. Yes. Which was aimed at Mr. Zimmerman's house. That's not they were positioned correctly. Mrs. Hutchison, yes or no, were your sprinklers spraying water onto Mr. Zimmerman's property and foundation for multiple months? Long pause. There may have been some overspray. 20+ minutes of sustained water exposure, twice daily for over 2 months is more than overspray, isn't it? I don't know what his sensors actually detected. You've seen the video evidence. Videos can be misleading. Teresa let that hang in the air. No further questions. The jury deliberated for less than 4 hours. They found in my favor on all counts. Brenda was ordered to pay me $32,400, covering the foundation repairs, increased water bills, sensor and camera costs, legal fees, and emotional distress. The jury rejected her counterclaim entirely. I felt vindicated but exhausted. The trial had consumed months of my life. I'd spent countless hours dealing with lawyers, collecting evidence, and stressing about my house. The money would cover the repairs and legal costs, but I'd lost months of peace and productivity. The HOA retaliation lawsuit settled in December. The HOA board, which by that point had removed Brenda as vice president due to the bad publicity, agreed to void all the citations she'd issued against me, remove any fines or liens, and pay me $12,000 for my legal fees and trouble. They also agreed to implement new procedures requiring board oversight for any citations issued by individual board members, specifically to prevent this kind of abuse in the future. Brenda appealed the judgment, which delayed payment, but her appeal was denied in March. By April, I'd received the full $32,400. I immediately hired Ron's company to do the foundation repairs. They cleaned and sealed the concrete, applied waterproofing, and installed a proper drainage system along that side of the house. The work took 3 weeks and cost $4,100, slightly less than estimated. My foundation was saved. My house was secure. And I had documented proof that sometimes, when you're dealing with a vindictive HOA Karren, the answer is data. Cold, objective, time-stamped data that can't be argued with. Brenda never spoke to me again. She avoided me completely, even when we encountered each other at neighborhood events. She eventually resigned from the HOA board entirely after the other residents started questioning her judgment. I kept the moisture sensors installed. They still log data continuously, though now they just show baseline readings. I check them occasionally, more out of habit than concern. They're a reminder that sometimes protecting yourself means going beyond just taking pictures or making complaints. Sometimes you need evidence that's irrefutable. The whole experience taught me several things about dealing with HOA disputes and vindictive neighbors. First, document everything immediately. The moment I suspected something was wrong, I started taking pictures and videos. Those became crucial evidence. Second, invest in objective monitoring if possible. The moisture sensors cost me $600 total, but they provided data that no one could credibly dispute. Third, don't try to handle it yourself. Teresa was expensive, but she knew the law and how to present evidence effectively. I would have lost without her. Fourth, be prepared for retaliation and document that too. Brenda's citation spree actually helped my case by demonstrating her malicious intent. Most importantly, I learned that HOA officers aren't above the law. Brenda thought she could use her position to harass me into submission. She thought that because she was vice president, she could issue bogus violations and get away with deliberately damaging my property. The courts disagreed. Her position gave her responsibility, not immunity. The neighborhood dynamics shifted after the lawsuit. Other residents who'd been afraid to challenge HOA citations started pushing back. 2 other board members resigned after residents demanded accountability. The new board implemented reforms. Violations now require photo evidence. Residents have a formal appeal process, and board members can't issue citations against their immediate neighbors without oversight. My relationship with the HOA stabilized. The new board president, a reasonable guy named Marcus who lived 3 streets over, actually apologized to me on behalf of the organization. "What happened to you was wrong," he said. "We're trying to make sure it doesn't happen to anyone else." I stayed in my house. I'd considered selling after all the stress, but ultimately I'd fought too hard to let Brenda drive me out. My desert landscaping still doesn't require irrigation. My rock gardens still look beautiful. My foundation is solid and properly protected. And every morning and evening, when I would have been listening to Brenda's sprinklers hammering away at my house, I now hear nothing but the quiet desert evening and the occasional bird. It's peaceful. It's what I paid for when I bought this house. The total cost of Brenda's vendetta, not counting her legal fees, $32,400 in damages to me, $1,000 in contempt fines to the court, and whatever she paid Mitchell to represent her through a trial and failed appeal. Probably another $40,000 to $50,000 in legal fees. All because she couldn't stand that I'd complained about a legitimate problem. Some people would say it wasn't worth it, that I should have just installed a barrier or lived with the moisture issue. But this was my home, my foundation, my largest financial investment, and beyond the money, it was the principle. Brenda thought she could destroy my property because she didn't like me or my landscaping choices. She thought her position in the HOA made her untouchable. The moisture sensors proved otherwise. 3 small devices, logging data every 60 seconds, creating an irrefutable record of exactly what was happening. No amount of denials or explanations could overcome that data. The timestamps were cryptographically verified. The patterns were consistent. The spikes corresponded exactly to her irrigation schedule. In court, Mitchell had tried to suggest I'd somehow fabricated the data. Teresa had shut that down immediately by explaining the technical impossibility of hacking commercial cloud servers to insert fake historical data across multiple independent devices. The jury understood. You can't argue with data that's been continuously logged and time-stamped by independent systems. That's what made this case different from typical neighbor disputes. Usually, it's one person's word against another's. He said, she said. Opinions about whether overspray was excessive or whether damage was significant. This case had objective proof. 90% moisture readings on sensors that should never exceed 10% in Phoenix. Video of water arcing across property lines. A professional engineer's report documenting concrete damage. Brenda's mistake was underestimating me. She thought I was just another homeowner she could bully. She didn't expect me to install industrial monitoring equipment. She didn't expect me to document everything meticulously. She didn't expect me to hire a lawyer who specialized in property disputes and understood how to present technical evidence. Most of all, she didn't expect me to follow through. She thought I'd complain, she'd ignore me, maybe I'd file one complaint with the HOA, and then I'd give up. Most people do give up when facing an HOA officer who's willing to retaliate. The hassle and expense of fighting usually isn't worth it for minor issues. But this wasn't minor. This was foundation damage. This was thousands of dollars in repairs, and potentially tens of thousands more if it continued. This was my home becoming structurally unsound. I couldn't just let it go. The sensor logs from the entire period are still stored in my cloud account. Months of data, over 3 million individual readings, all showing the same story. Normal baseline, sudden spike, sustained elevation, gradual decline. Twice daily like clockwork, for 68 consecutive days until the court ordered it to stop. I showed some of the data visualizations to my colleagues at work. One of them, a data scientist, said it was some of the cleanest before and after data he'd ever seen. You could see the exact moment the sprinklers turned on in the data, all 3 sensors spiking simultaneously within seconds of each other. You could see them running, all 3 maintaining elevated readings. You could see them shut off, all 3 beginning to decline within a minute. This is incredibly damning evidence, he said. There's no alternative explanation. Something was spraying water on those sensors at the same time every day. The only question is what, and the videos answer that. That's what Judge Orozco had understood immediately. When you have video showing sprinklers spraying a house, and sensor data showing moisture spikes at the exact times the sprinklers run, and all of it happening day after day for months, there's no mystery. It's cause and effect, documented beyond any reasonable doubt. The The jury understood it too. During deliberations, they'd asked to review the sensor data graphs again. They'd spent time looking at the patterns. According to Teresa, who spoke to a couple jurors afterward, the data was what convinced them. They could see Brenda was lying about when she adjusted the sprinklers, because the data showed no change in the pattern until mid-July when the court forced compliance. The appeals court understood it as well. Brenda's appeal had argued that the damages were excessive and the sensor data was unreliable. The appeals court disagreed on both counts. The foundation inspection report had documented real damage requiring expensive repairs. The sensor data was properly authenticated and clearly reliable. Appeal denied. Now, almost a year after this all started, my life is back to normal. My foundation is repaired and properly sealed. My water bill is back to $80 a month. My sensors show baseline readings. The HOA leaves me alone. Brenda keeps to herself. I see her occasionally, getting into her white Lexus or checking her mail. She never acknowledges me. That's fine. I don't need her friendship or even her civility. I just need her to stay on her own property and mind her own business. The experience changed how I think about property ownership and HOAs. I used to think HOAs were just annoying bureaucracies that enforced picky rules. Now, I understand they can be genuinely dangerous when bad actors get into positions of power. Brenda had the authority to issue fines and place liens on my property. She had credibility with other residents and board members. She used all of that to try to bully me into submission. If I hadn't documented everything, if I hadn't installed the sensors, if I hadn't hired Teresa, I probably would have lost. It would have been my word against hers, and she was the vice president. The board would have believed her. I'd have been stuck with an accumulating pile of fines and possibly a lien on my house, while my foundation slowly deteriorated. The sensors changed everything. They turned, he said, she said dispute into an objective fact pattern. They took credibility out of the equation. It didn't matter that Brenda was vice president or that I was just a regular homeowner. The data was the data. That's my advice to anyone dealing with a similar situation. Document with objective evidence. Photos and videos are good, but they can be dismissed as showing isolated incidents or misleading angles. Sensor data, especially continuous automated logging, is much harder to dispute. It shows patterns over time. It removes human bias and judgment from the equation. Of course, most people don't happen to have industrial moisture sensors lying around, but similar principles apply. If you're dealing with noise complaints, get a calibrated sound meter that logs data. If you're dealing with boundary disputes, get a professional survey with GPS coordinates. If you're dealing with parking disputes, get time-stamped photos from multiple angles. Whatever the issue, find a way to create objective evidence that doesn't rely on subjective interpretation, and get a lawyer early. I waited a few weeks before contacting Teresa, trying to resolve things directly first. That was probably a mistake. Brenda had already established a pattern of non-cooperation by then. If I'd involved Teresa immediately after the first certified letter went unanswered, we might have gotten a TRO sooner and prevented some of the damage. The legal system worked, eventually. It took months and cost money, but it worked. The court looked at the evidence, determined the facts, and enforced my property rights. Brenda was held accountable. I was compensated for the damage. The system isn't perfect or fast, but it's better than vigilante justice or just accepting abuse from powerful neighbors. I'm still glad I installed those sensors. They cost $600 and saved me from potentially tens of thousands in uncompensated damage. They provided peace of mind during the months of litigation. I knew exactly what was happening to my foundation in real time. And they proved, beyond any doubt, that I was telling the truth. The house is quiet now in the evenings. The sensors still ping data to the cloud every 60 seconds, showing boring baseline readings around 5 or 6% moisture. That's exactly what I want to see. Boring data means nothing is wrong. I keep the sensor dashboard up on my phone sometimes just to check. It's become a habit. A quick glance at the graphs shows me everything is stable. No spikes. No problems. Just 3 flat lines showing normal environmental conditions. My foundation is safe. My house is secure. And Brenda Hutchison learned an expensive lesson about the consequences of using HOA power for personal vendettas. Sometimes the little guy wins, especially when he brings receipts in the form of 3 million timestamp data points. The rock garden is doing well, by the way. The native plants thrived through the summer heat with minimal care. The decorative stones stayed in place, except during that one dust storm. The whole setup requires maybe an hour of maintenance per month, mostly just sweeping and occasional weeding. That's what Brenda never understood. My landscaping wasn't laziness or disregard for the neighborhood. It was thoughtful design for the desert environment. Low water usage, native plants adapted to the climate, sustainable and practical. It looked different from her water-intensive lawn and flower beds, but different doesn't mean wrong. She couldn't accept that someone might make different choices than her and still be right. She couldn't accept that I could live in the HOA community and follow the rules while doing things my own way. Her need for conformity and control led her to make catastrophically bad decisions. Pointing sprinklers at someone's foundation is insane. Even if you hate your neighbor, even if you think their landscaping is ugly, deliberately causing water damage to their house is illegal property destruction. It's potentially criminal vandalism. Brenda was lucky. I pursued a civil suit for damages rather than pushing for criminal charges. The district attorney might have charged her if I'd pushed the issue. Deliberate property damage exceeding a certain dollar threshold is a felony in Arizona. The censored data and videos would have been admissible in criminal court. She could have faced actual jail time, but I didn't want revenge. I wanted my foundation fixed and my legal costs covered. I wanted her to stop destroying my property. The civil suit accomplished all of that. Adding criminal prosecution would have just prolonged everything and required more of my time and energy. Sometimes winning means knowing when to stop. I got the judgment. I got paid. The damage is repaired. Brenda lost her HOA position and her reputation in the neighborhood. That's enough. The case is closed now, legally and practically. The appeals are exhausted. The money is paid. The repairs are complete. Life goes on. But I'll never forget the satisfaction of sitting in that courtroom while Teresa displayed the moisture sensor graphs on the big screen, showing month after month of damning data. The jury leaned forward to study the patterns. The judge nodded, understanding immediately what the data proved. And Brenda's lawyer sat there with nothing to say, because you can't argue with 3 million data points all telling the same story. That's the power of evidence. That's why documentation matters. And that's why, if you're ever in a property dispute with a vindictive neighbor or HOA officer, you should invest in objective monitoring. It might cost a few $100s upfront, but it could save you thousands or tens of thousands down the road. My moisture sensors are still there, mounted to my foundation, quietly logging data every 60 seconds. They'll stay there as long as I own this house. They're my insurance policy, my early warning system, and my protection against any future nonsense. Brenda's sprinklers still run twice daily, but now they water only her own property. The landscaping crew she hired actually did a good job with the adjustment. The water stays on her side of the property line. My sensors confirm it every single day. And every evening when I sit on my back patio with a cold drink, watching the desert sunset paint the sky orange and purple, I'm grateful for those sensors. They saved my house. They proved my case. They turned what could have been a hopeless dispute into a clear victory. Sometimes technology really does solve problems. And sometimes the best way to fight an HOA, Karren, isn't with anger or escalation, but with data. 3 industrial-grade moisture sensors, logging continuously to the cloud, collecting irrefutable evidence 1 reading at a time. That's how you win against someone who thinks their position makes them untouchable. You bring proof they can't deny, numbers they can't spin, and timestamps they can't dispute. Gabriel Zimmerman versus Brenda Hutchison. Final score: $32,400 and 1 intact foundation. Victory by sensor data. The house is mine, the foundation is solid, and the sprinklers stay on their own side of the property line. Everything is as it should be. Everything is documented. And if anything ever changes, I'll know within 60 seconds because 3 sensors are always watching, always logging, always protecting my home. That's the end of the story. The sprinklers are adjusted. The damage is repaired. The lawsuit is won. The HOA Karren learned her lesson. And I learned mine. When someone powerful decides to come after you, the best defense is evidence they can't explain away. Mission accomplished. Foundation saved. Case closed.